Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I have the latest filing for you in the Justin Baldoni versus Blake Lively universe. In this one, Ryan Reynolds responds to Justin Baldoni and Wayfarer's response to his motion to dismiss. So these things come in three parts, right? So it goes motion to dismiss, the opposition responds to the motion to dismiss, and now this is the final stage where the original party will respond again. And I know a lot of people will say, like, they're trying to bog the judge down with filings, but I may not be a lawyer, but one thing I do know is that this is pretty standard. So, nothing too controversial there. But let's see what they have to say, because I have not read it yet. And of course, as always, I'll post a link to these filings not too long after the stream ends. It's just I have a lot of stuff to do. I was working on a Bachelor related stream before this. I put out another video tonight, so I've been real busy. But I will, if you guys, especially if you need to remind me, I will always post a link. So, and usually it comes up on Court Listener anyways. So, my friend Bruce from Oregon is here. Thank you, Bruce, Sarah, Teresa, and my other mods. I appreciate it. I'm just trying to give people another 30 seconds or so to filter in before we start. If you like the Justice for Justin shirt in my background there, my friend Zach Peter sent it to me. And he's still doing a campaign through Monday where if you buy a shirt or you buy any kind of merch, I think, from that selection, he's sending 50% of the proceeds to No More, the organization that supports domestic violence victims, the one that Justin Baldoni and Wayfarer partnered with for the film It Ends With Us. So I think it's a good cause and a cool shirt. I would wear it on the stream for you, except obviously my camera is so close up you can't see it, so I decided to put it in the background anyways. Just so you can see the whole thing. All right. Let's get into it, shall we? Introduction. The Wayfarer Party's opposition confirms the central thesis of Mr. Reynolds' motion to dismiss. The FAC is a meritless list of grievances and hurt feelings, again with the hurt feelings, designed to retaliate against Blake Lively for raising sexual harassment and retaliation claims. And I can already tell this is going to be a bunch of bullshit. So remember, guys, if you don't have the time to sit with me through reading this entire document, I will do a short recap tomorrow morning that'll come out. So if you could just please hit the like for me, share, subscribe, whatever you feel like doing. It really helps me out. And I do also put out short form content. I just like to be able to react to these things with you guys in real time. Okay. The opposition is riddled with fatal concessions. As one example, despite the FAC's preposterous $400 million damages claim, the opposition concedes that the FAC, in fact, alleges no actual monetary harm whatsoever, instead relying exclusively on a defamation per se theory that, even if it were valid, which it is not, fails to allege cognizable damages for any of the FAC's other claims. Okay. In addition, the opposition concedes the FAC does not allege proximate causation, another fatal omission. Okay, then. Let me just take these off because maybe my brain's not working because of the sound block or something, even though this is a written document. The opposition reveals something much worse than the FAC's failure to state valid claims against Mr. Reynolds. Stunningly, it confirms that only 3 of the Wayfarer parties, Mr. Baldoni, Mr. Heath, and Wayfarer Studios LLC, have articulated any legal claim against Mr. Reynolds at all. What planet are you living on? Okay. As detailed further below, the sole alleged defamatory statements concern only Mr. Baldoni, infra at 4. The only alleged conduct as to extortion was directed at most at Wayfarer Studios, Mr. Baldoni and Mr. Heath, infra at, and they're citing a spot there. And the only parties even arguably in contractual relationship with WME were Wayfarer and Baldoni. But, disregarding their Rule 11 obligations, every Wayfarer party asserted each claim against Mr. Reynolds, meaning that every Wayfarer party, other than Baldoni, brought a federal lawsuit alleging at least one cause of action that they know they had no legal basis to assert. None of Mr. Sorry. None of Mr. Sarowitz, Miss Nathan, Ms. Abel, It Ends With Us movie, or Tag has a single cause of action against Mr. Reynolds that they even arguably possess. All of those claims should be dismissed, and Mr. Reynolds should be awarded his attorney's fees and costs under applicable New York law. Okay. There's a footnote here. It says, except for internal cross references within this document, pin sites? I've never seen that word before. Pin sites to refer to ECF pagination and capitalized terms mean the same as in Mr. Reynolds' motion to dismiss. Congrats, I guess. All right. Just watch your other video on Gabby and Clayton. So well said. Thank you for covering that. Oh, no problem. Thank you for watching that, Meg. Give me 1 second. I need some water. Okay. Somebody says they're going with the group pleading again. Technically, yeah, I know. All right. The FIC fails to state a defamation claim. The claim is meritless under New York or California law. All of the claims against Mr. Reynolds must be dismissed regardless of which state's law applies, rendering a choice of law analysis unnecessary. But to the extent such analysis is required, New York law applies to each claim asserted against Mr. Reynolds. The Wayfarer parties concede this via silence as to all but the defamation claim, as they acknowledge the analysis must be conducted separately for each individual claim, but they respond to Mr. Reynolds' choice of law arguments only with respect to the defamation claim. With respect to the defamation claim, the presumption that the state of the plaintiff's domicile will usually have the most significant relationship to the case, at 15 emphasis added, does not apply here because all of the relevant conduct occurred in New York. The Wayfarer parties, no, hold on, because they've argued that the filming actually happened in New Jersey. So how would that be true? Okay. The Wayfarer parties concede that the only statements of Mr. Reynolds alleged in their first amended complaint were the predator statements. So I guess they're just talking about, they're just talking about Ryan's statements, which I guess happened in New York. I don't know. Okay. The predator statements, I like that they capitalize that like it's a proper noun. Like it's an important thing. The predator statements is like a whole thing now. All right. Which the FAC claims were uttered in New York. Okay, so that is correct. Okay, got it. FAC, and the FAC expressly alleges that the Wayfarer party's injuries were experienced in New York. Even if some portion of the alleged injury occurred elsewhere, where the alleged conduct and alleged injury take place in different jurisdictions, it is the place of the allegedly wrongful conduct that generally has superior interest in protecting the reasonable expectations of the parties who relied on the laws of that place to govern their primary conduct, and in the admonitory effort that applying its law will have on similar conduct in the future. Hold on. Let me think about this. Even if some portion occurred elsewhere. Okay. It is the place of the wrongful conduct that generally has superior interests in protecting the expectations. Okay. So this is something you would rely on if you were like one of those people who was technically an asshole, but I could totally get away with it. You know what I mean? Like that's what that reads as to me. But we'll wait for the two lawyers to explain that. B, the FAC fails to adequately identify any defamatory statements. Well, that's certainly not true, but okay. In case you forgot to hit the like button, thank you very much, Nanny. I appreciate it. Hey, CJ, what's going on? Also, like I said, I had a gift that I'm not showing today. I'm going to show it tomorrow, the next night, from one of my viewers. But also, one of you sent me some socks with bacon and eggs on them, which was pretty cool. And I don't want to call that person out just in case they don't want me to say their name. But I'm pretty sure they're in the chat right now. So thank you very much for sending me those socks. I'm going to be wearing them a lot. All right. Let's see. Exhibit A, which is the evidence timeline, is not part of the FAC, and whether struck or not cannot be properly considered in asserting the sufficiency of the Wayfarer party's defamation claims. The FAC does not sufficiently identify what Mr. Reynolds said when he said it. What? When he said it, or to whom he said it, which is fatal to the defamation claims. What are you talking about? Beyond the predator statements, I mean, I guess in the response to the motion to dismiss they did, but maybe, I don't know, but that's why they said, they were asking for the motion to dismiss to be denied, or for them to be given permission to amend their complaint, which is where they could, put that information in. Beyond the predator statements, the Wayfarer party, the fact that this man has to have somebody put predator statements in a filing for him says something. All right. The Wayfarer parties argue that the FAC sufficiently pleased that Mr. Reynolds defamed them by working in concert with Lively and the Sloan parties through statements to third parties, including at least to the New York Times. Despite the Wayfarer parties' claims that these statements were widely disseminated, the FAC does not plead a single actual statement or any details about any such statements. Such vague allegations fail to state a claim. Alrighty then. C. Mr. Reynolds' statements are not of and concerning 6 of the 7 Wayfarer parties. Okay. I mean, I can kind of just trying to be removed for a second, and before reading the paragraphs, I'm like, okay, maybe they're trying to say, that it was just about Justin, it's not about these other guys, but at the same time, the reason I do this is because I'm looking at things from a layperson standpoint. And from a layperson standpoint, I don't give a shit if you were talking about half of one of the 7 Wayfarer parties. You lied, and you're a piece of crap. So, but let's keep going, shall we? All right. The Wayfarer parties concede that the predator statements relate only to Baldoni. Well, congrats. You're still an asshole. Meaning that these alleged falsehoods were not of and concerning them. While the Wayfarer parties also contend that Mr. Reynolds' other unidentified statements to unidentified third parties were about the other Wayfarer parties, this singular allegation fails to satisfy the standard they concede applies. Their attempt to meet this requirement through a small group exception fails because even this requirement, requires allegations about a defined group. Here, there is no such allegation, and this failure mandates dismissal as to all Wayfarer parties but Baldoni. And wow, that doesn't mean he still wasn't lying about Baldoni. Hang on. I'm asking Omar, the Tilted Lawyer, to stream with me at, it would be 11 Eastern. Hang on, it's a new filing. Okay, so I'll probably go over this with Omar in a couple hours to go over the legal implications and stuff like that. But anyways, I just wanted to put that out there. Their attempt to meet this requirement through a small group exception fails because even this requires allegations about a defined group. Here, there is no such allegation, and this failure mandates dismissal as to all Wayfarer parties but Baldoni. D. The predator statements. I feel like this is about a different movie. I feel like this is about the movie Predator. The predator statements are unactionable opinion, and we've kind of been through this before where he's like, I really believed it. You know what I mean? Like that kind of thing. But no, you didn't. The predator statements constitute protected opinion under the governing law in its circuit. The Wayfarer parties argue that context demonstrates that the predator statements implied undisclosed facts and were made in an effort to force WME to drop Baldoni. But neither the opposition nor the FAC identifies which undisclosed facts may have been implied. Instead, the FAC's allegation of Mr. Reynolds' purported disdain for Mr. Baldoni demonstrates that his impassioned comments were likely to be opinion, not fact. The opposition, this is E, the opposition confirms the conclusion that the alleged defamatory statements are substantially true. Okay. Every now and then I look back and I'm like, imagine if I was muted this whole time. That's my biggest fear on streams. That's my biggest fear on streams. Off of streams, all kinds of stuff. But yeah. All right. Can you really call it a unicycle if it has 4 training wheels? I don't think so, Bruce, but I've never tried it, so you tell me. All right. The Wayfarer parties claim that the court cannot conclude as a matter of law that Baldoni is a sexual predator, but the substantial truth doctrine does not require the court to make any such determination. Okay. And I'm just going to point out again, the court may not be required to make such determination, but as a member of the public, you're a piece of shit, Ryan. Okay. Anyways. Instead, dismissal is warranted where, as here, the allegedly false statements would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. Okay. Ooh, my bad. The Wayfarer parties do not address the cases holding and therefore concede the court can take judicial notice of Mr. Baldoni's public statements and otherwise offer no basis for the court to conclude that those statements, i.e. the pleaded truth, would have different impact on a listener than the allegedly false ones, i.e. that Mr. Baldoni has acted in a predatory manner. Likewise, to the extent the court finds that the Wayfarer parties otherwise sufficiently allege some unidentified statements to the New York Times, good Lord, and unnamed third parties, there would be no different effect on the reader between Mr. Baldoni's own statements and those unspecified statements. F. The FAC fails to allege actual malice. To show actual malice, the Wayfarer parties rely heavily on allegations relating to Mr. Baldoni. Oh my goodness, what did I just do? Sorry about that. I hit a button. Oh no, I hit a button. Oh no, it's bad. Oh no. Okay, where is F? Different F. Okay, hang on, guys. Bear with me. And there it is. Okay. My bad. Okay. But allegations of motive, do not suffice to demonstrate actual malice. The Wayfarer parties also argue that Mr. Reynolds got hold of communications between the Wayfarer parties from Stephanie Jones. Yeah. That disproved the claim that the Wayfarer parties had orchestrated a smear campaign. But that claim is nonsensical. How is that nonsensical? For starters, the FAC does not... How are you going to call that nonsensical when your wife is like... Never mind. That's not the point of this stream. Anyways, the FAC does not allege anywhere that Mr. Reynolds has access to any such materials at the time his alleged statements were made. And in any event, the conclusory assertion that those materials disproved any smear campaign is directly contradicted by the communications. Although the Wayfarer parties argue that Mr. Reynolds' actual malice is established by the inherent improbability of an untraceable campaign, they have admitted to just such a campaign in their own words. What are you talking about, dude? Thus, the only reasonable conclusion is that Mr. Reynolds would have believed in the existence of a smear campaign. What the fuck are you talking about? That doesn't even add up. Can someone explain that to me? Like, seriously, does anybody else know how that adds up? I don't see it. Oh my lord. Oh, says, I just watched an old video of yours and I cackled so hard at your cesspool as my jacuzzi. Yeah, thank you very much. Anyways. I'm very confused by what they're saying right now because it does not preclude him from sounding like a terrible person. In my opinion. But, okay. 2, the FAC fails to state a false light claim. New York law applies to the false light claim against Mr. Reynolds. As discussed above, the alleged slander, the predator statement, was made and published entirely in New York by a New York resident. In those circumstances, New York has the greatest interest in regulating the in-state conduct of its resident. And under New York law, there is no such thing as a false light claim. Even in California law, or even if, California law were to apply, however, the false light claim against Mr. Reynolds must be dismissed as duplicative. While conceding that a false light claim is duplicative when based on the same single statement as defamation claim, the Wayfarer parties assert that this false light claim is based on other allegations. But the cited paragraphs illustrate that the FAC alleges no facts with respect to Mr. Reynolds aside from the allegedly defamatory statement attributed to him. Paragraph 162 mentions the predator statement, the precise statement on which the defamation claim is based, and then details allegedly distorted text messages from a legal complaint that Ms. Lively prepared and filed. Similarly, paragraphs 274 to 282 similarly discuss excerpted text messages in Lively's CRD complaint and do not mention Mr. Reynolds at all. The opposition thus confirms that the false light claim as to Mr. Reynolds is based on exactly the same statement that supports the defamation claim and therefore must be dismissed as duplicative. Okay. Collecting cases and dismissing a false light claim because the opposition brief only confirms that the false light claims and the defamation claims involve precisely the same facts. once again, I'm just going to reiterate, as a layperson, because it does matter. It does matter in this case what the public thinks of these people, because they're entertainers, right? They're actors for a living. And I know that they have their side businesses or whatever, but obviously the hair care line is not doing too well per themselves. So, you know, as a public consumer, I gotta say, this does not make you look any better from a public standpoint. So, like, I think it was a mistake for them to bring this lawsuit at all, because um, I don't think that if you actually read the lawsuit, if you actually know what's going on, which is going to happen, because this is going to gain steam, even if it's not a filmed trial, it's going to gain steam like Johnny Depp and Amber Heard. Okay. From a public perspective, you look like an asshole. What you're saying right here makes you look like an asshole. Even if you're correct about the technicalities of the law, you look like an asshole. It's not good for your brand. So maybe you shouldn't have pretended that your wife was sexually harassed. All right. The civil extortion claim and tortious interference claims must be dismissed as to Mr. Reynolds. A, the FAC fails to allege damages and proximate causation, which is fatal to both the tortious interference and civil extortion claims. The Wayfarer parties do not dispute that they have failed to allege any damages arising from Mr. Reynolds. What? What? What are you talking about? They don't allege any damages arising from Mr. Reynolds' conduct. What filing were you reading, bro? Indeed, although Mr. Reynolds raised this issue in his motion to dismiss, the Wayfarer parties simply ignore it. No, I'm just kidding. Totally kidding. Their entire discussion of damages is contained in their discussion of a defamation per se theory, premised on the notion that they have not and need not allege special damages, i.e. pecuniary harm. Okay. What is right? Can't wait to hear from Omar. Yeah, I texted Omar. We're going to be streaming in, that's only like an hour from now. So don't forget to look out for that. The Tilted Lawyer, Omar, if you're not following him yet, because he is awesome. Give me 1 second. Which will give me a breather from reading this shit. I hate when I'm reading alone, because it's like I'm just reading straight through. This is my buddy Omar, who I'm going to be on with later for him to explain the legal stuff. I think he might be collaborating with the Ask Two Lawyers at some point soon, he said. So I'm not sure if they have anything exact planned, but I'm posting on the chat right now, because that's where I'm going to be in about an hour. Okay, there we go. I pinned it. Okay. But yeah. Let's keep moving on, shall we? Similarly, Wayfarer concede they have failed to allege that any conduct of Mr. Reynolds proximately caused any damages. The words proximate cause do not even appear in their opposition brief, another concession warranting dismissal of the tortious interference and civil extortion claims. These concessions are fatal to the tortious interference claims under both California and New York law, obviating the need for further analysis. Indeed, as the Wayfarer party's own case confirms, liability for tortious interference with contract is limited to pecuniary loss. Okay. Hang on. Okay. The civil extortion claim must be dismissed. Wayfarer assert that California law applies to the civil extortion claim, but despite that, choice of law analysis is conducted separately for each individual claim. They do not analyze choice of law with respect to the civil extortion claim, resting solely on authorities limited to defamation. The Wayfarer parties effectively concede via silence that New York law applies to the civil extortion claim because civil extortion is a conduct regulating tort that must be governed by the law of the state where the conduct occurred. The independently warrants dismissal. Sir. Even under California law, the claim warrants dismissal. The Wayfarer parties assert that Mr. Reynolds points to no authority that California courts limit the claim, but failed to address Mr. Reynolds' discussion of Furman v. California satellite systems, which Lauren knows nothing about. But Omar will, so that's why you should watch us in about an hour on his channel. Instead, the Wayfarer parties continue to rely on a small handful of federal cases without reference to state court decisions or even engaging with federal cases that disagree with their position. Regardless, the Wayfarer parties also declined to defend their allegations of civil extortion as compliant with Rule 9b, as they must be to survive dismissal. Nor do the Wayfarer parties explain how this claim could survive their general failure to allege any damages, let alone a deprivation of money obtained by Mr. Reynolds or any of his co-defendants from any of the Wayfarer parties. Each of these omissions amounts to a concession that is independently fatal to the Wayfarer party's civil extortion claim. Even if it were permissible to plead extortion while admitting there was no loss of money or property, it is axiomatic that there could not be a civil cause of action to recover no damages at all. The Wayfarer parties rely on cherry pick. You want to talk about cherry picking, bro? Cherry pick language from Monarch's Deposit Company versus Gilliam, in which there was a demand for money, to argue that California law prescribes extortion, notwithstanding that the defendant ultimately obtained no money or property by means of his extortionate threats. But Monarch's has been repeatedly criticized and lends no support to the Wayfarer parties here, where there was conceitedly no demand for money or property. Really? No demand. Really? Okay. No demand for money or property. Just a request for a public apology. You got the demand part confused. The demand was for the public apology. After no such behavior occurred, in my opinion. But okay. That's just me. I'm very opinionated in this case. I'm not going to lie to you. So. All right. The tortious interference claims must be dismissed, and this is C. Contrary to the Wayfarer party's assertions that California law should apply to the tortious interference claims, let's see. New York law would apply to the tortious interference claims because all of the relevant conduct occurred in New York, and New York has a greater interest in regulating business conduct within its borders. Manbro Energy Corp versus Chatterjee Advisors. Manbro? Is that someone's actual name? Manbro? I mean, that's... Okay. Regardless, the tortious interference claims must fail under either state's law, even Manbro's law. As an initial matter, the Wayfarer parties do not dispute that they have failed to allege damages, which is fatal to their tortious interference claims. Similarly, Wayfarer concedes, again via failure to respond, that they have failed to allege any conduct by Mr. Reynolds that proximately caused any damages. Both concessions are fatal under New York or California law. Okay. We got 5 pages left, so we're going to power through this, guys. The FAC also fails to allege the remaining elements of any tortious interference claim. The Wayfarer parties concede that these claims depend exclusively on the allegation that Mr. Reynolds expressed his deep disdain for Baldoni. It was a bit more than that. To a WME executive. Referred to Baldoni as a sexual predator. Yep, that's a problem. Demanded that the agent drop Baldoni. Also a problem. And demanded an apology for misconduct on the set of the film. This, the Wayfarer parties contend, induced WME to cease performing under its contract with the Wayfarer parties. Those bare allegations are insufficient. As for intentional interference, regardless of which state laws apply, there is no dispute that the FAC does not set forth the essential terms of a contract, written, oral, or implied. Even under California law, it's impossible to know whether the contractual relationship was disrupted through a cessation of performance without knowing what contractual duty WME ceased performing. For real. I think we can tell. And moreover, the absence of any allegation that the contract was not at will means that this claim must be dismissed under New York law, or, if California law applies, must satisfy the elements of intentional interference with prospective economic advantage, as the Wayfarer parties concede. Okay. The FAC does not allege the independent elements of intentional interference with economic advantage. Indeed, the FAC does not allege a single economic relationship lost because of the alleged interference. What? I'm sorry. With the WME relationship. Is that a joke? In their opposition, the Wayfarer parties assure the court that discovery is likely to show that there were specific interested counterparties inquiring with WME to engage the Wayfarer parties, but that is their pleading burden, not a set of facts they are entitled to wait for discovery to allege. So, in other words, yeah, they said that, but they can't prove it. It's not that I didn't do it, but they can't prove it. Okay. Nor does the FAC allege an independently wrongful act. What? As required to state a claim for interference with prospective economic advantage. I feel like it was alleged. That's just me, though. I mean, okay. Anyways. Moreover, by seeking to recover for that statement in defamation and tortious interference, the Wayfarer parties are seeking a double recovery that renders the intentional interference claim duplicative. Finally, with respect to negligent interference, which does not exist in New York, the Wayfarer parties expressly concede that California law does require a plaintiff to plead a duty of care, and that the FAC does not directly address this legal issue. Okay. The Wayfarer parties speculate that a contract between Reynolds Company and an unspecified Wayfarer party may have created such a duty, but refuse to say anything about this contract, which they presumably possess beyond their abstract speculation. This concession alone warrants dismissal with prejudice. There's a footnote here. It says the sole case that the Wayfarer parties cite to defend the practice of bringing defamation claims and intentional interference claims arising from the same facts under California law, Marsh, did not actually approve of that practice. There was no defamation claim at issue. Okay. D, the FAC fails to allege conspiracy liability. All right, we're on the last 3 pages here, guys. The Wayfarer parties do not dispute that all of their conspiracy allegations are made on information and belief, or that such allegations are insufficient to allege conspiracy liability. Instead, they simply assert they have pleaded ample allegations in connection with each cause of action against Reynolds to support the existence of a conspiracy at the pleading stage. But they mention only one such allegation, namely that Reynolds and Lively made a joint threat to attack the Wayfarer parties in the press. Okay. Paraphrasing paragraphs in the FAC that allege that the Wayfarer parties were informed and presumably believe that Mr. Reynolds and Ms. Lively had requested a public apology for misconduct on the set of the film. It wasn't so much a request as a demand, but sure. Even taken as true, that allegation of joint action is not suggestive of any agreement to do anything unlawful or a common plan or design to perpetrate a tort. Okay. And even if it were, it relates only to the civil extortion claim as to which the FAC alleges no damages, not to each cause of action. Mr. Reynolds is entitled to attorney's fees. The Wayfarer parties do not dispute that New York law applies to Mr. Reynolds' entitlement to anti-SLAPP attorney's fees, but instead incorrectly claim that Section 70-A1's fee shifting provision does not apply in federal court. Okay. The Wayfarer parties concede that the Second Circuit has not directly addressed the question of whether New York's anti-SLAPP law applies in federal court, but urges this court to follow La Liberté versus Reed. But La Liberté itself perfectly illustrates the relevant distinction there. The Second Circuit reasoned that California's anti-SLAPP statute awards attorney's fees only to a prevailing defendant on a special motion to strike and does not purport to make attorney's fees available to parties who obtain dismissal by other means, such as under Federal Rule 12. P6. Okay. How's everybody doing? We're close to the end here, guys. How's it going, Amanda? What's up? Ryan Reynolds is a righteous wanker. All right. Okay. God, where did I even leave off? We're going to start here. In this scenario, applying mandatory fee shifting in federal court is unproblematic. The Wayfarer part, and that was referring to Chung v. Newman, I guess. The New York anti-SLAPP law does not have the feature of California's law that the La Liberté court considered fatal. Okay, a provision tying fee shifting to a specific state procedural mechanism. The Wayfarer parties insist that enforcing New York's fee for shifting provision would automatically sanction any plaintiff whose non-frivolous defamation claims failed on a Rule 12b6 motion. But that does not accurately describe the consequence of shifting fees under Section 70A1. It would apply not to any plaintiff who files a non-frivolous defamation claim, but every plaintiff who files a SLAPP claim and cannot even survive the 12b6 standard. And while loser pays regimes may be rare in the United States, New York law is designed to deter strategic lawsuits against public participation, which is what SLAPP is, strategic lawsuits against public participation, and thereby protect the free exercise of speech, petition, and association, okay, including by requiring SLAPP plaintiffs to bear the cost of meritless claims like those found in the FAC. 5, leave to amend should be denied. So he's saying they shouldn't even be able to amend their complaint. All right. The Wayfarer parties chose to amend as of right before seeing any party's motion to dismiss. And now that the defects in their claims have been pointed out, they repeatedly fall back on a request for leave to amend yet another time. But the Wayfarer parties have not moved for leave to amend or complied with Local Rule 15.1a, rendering their bare request to amend in a brief improper. And I noticed there are a lot of ellipses in there. So, in any event, their request is meritless because a plaintiff must provide some indication of the substance of the contemplated amendment before a court can entertain the request. And nowhere do the Wayfarer parties say what facts they could allege. Really? To cure the defects in the FAC, or why they could not have alleged those facts in either of their 2 prior complaints. In the absence of any identification of how a further amendment would improve upon the complaint, leave to amend must be denied as futile. And Omar, my friend, is going to tell us in like 52 minutes when I join his stream why they think that and whether or not it's valid. So how about that? Conclusion, all claims against Mr. Reynolds should be dismissed with prejudice without leave to amend, and the court should award Mr. Reynolds his cost, including attorney's fees. With prejudice means they couldn't bring a claim against him related to this again. So, like I said, my friend Omar is going to explain the legal stuff to us. So that will help. Because you guys know I'm just a layperson. It's a court of random opinion, not the court of an actual lawyer's opinion. So, yeah. It is what it is, but give me 1 second here, guys. I'm going to send you to... Who would I send you to? Let's say my friend Shizzy. Please send Shizzy lots of bacon emojis. As soon as I have the link to Omar's stream that I'm going to be on him with where he explains the legal stuff, I'm going to post that on the YouTube channel under the post tab. So you just go to my Court of Random Opinion YouTube channel, go to the post tab, or on X, Twitter, whatever you want to call it, and I'll post it there. So I will see you guys soon, hopefully. Please don't forget to leave a like on this video and also send lots of bacons and robots to my friend Shizzy Wiznut, who I'm sending you to now. Thank you, everybody. And now that this is fully briefed, by the way, the judge can rule on it at any time. So I will see you guys soon over at Omar's. Appreciate it. Bye-bye.